Welcome to Studio 58A live here at the Jamaica Information Service, our discussion program coming to you live on Facebook. I am your host, Vaughn Davis. Thank you so much for joining us online wherever you are around the world. We do appreciate it. As you watch, remember to send in your questions, your comments, so we can put them to our guests. And like how we have your attention, do us a favor now. Like this, share this feed to a friend or two or 30 so we can have a wonderful and lively discussion. Now, the government, through the Ministry of Economic Growth and Job Creation, is taking steps to amend the Rent Restriction Act to strengthen existing provisions and, more importantly, address challenges in the renting industry. And because everybody knows somebody with either a bad landlord or a bad tenant story, this is definitely a topic that we should all pay attention to. And here to discuss the amendment and a host of other issues are Senior Director for Housing Policy Research and Monitoring in the Monitoring Branch at the Ministry of Economic Growth and Job Creation, Ms. Paula Parks, which is to our far right. And beside her is Chairman of the Rent Assessment Board, Mrs. Rose Bennett Cooper. Thank you both ladies for joining us today.
My pleasure.
All right, so my first question, I'm going to start with you, Ms. Parks. Why amend the Rent Restriction Act at this time?
Well, just by way of background, the Rent Restriction Act was first enacted in 1944, and it has been amended 11 times so that it can put it within the social context of what is happening. But even though it has been amended 11 times, the latest being in 1983, it is still found wanting in some respect where it does not, some of the provisions are outdated and it cannot adequately deal with the challenges of the rental industry in 2018.
Okay, in 2018.
We have had a steady number of disputes. There are a number of issues, for example, security deposit, recovery of possessions that people keep talking about and complaining about. And as such, the Ministry of Economic Growth and Job Creation, under which housing and rental falls, decided that we will now at this time seek to amend the act.
Okay, wonderful. Now, you mentioned some of the issues that the new act will seek to challenge, but can you speak to some of the more specific provisions that the new act will seek to introduce insofar as security deposits, breach of landlord-tenant covenants, and recovery of possessions are concerned? You can take them one by one, or which one seems more topical for you, but you can just take them one at a time.
Okay, I will begin with the matter of security deposit, which is one of the main provisions that will be affected. Currently the Act, some may disagree, but currently the Act is silent on the use of security deposit, but it has become more a norm in our society today, so we need to look at having guidelines in relation to its use, what it needs to be used for, what it should be used for, and also in relation to refund of the security deposit to the tenant.
Okay.
From where we sit as members of the Rent Assessment Board, we get a number of disputes, a lot of
I would imagine.
Yes, from tenants that the security deposit is not returned, or it's not returned in full for one reason or the other.
But just clarify for me, what is the specific provision as it relates to security deposit as it stands now? Or is it, you said the law is silent on it, but what obtains or what generally tends to obtain? Maybe you can help her out, Miss Bennett Cooper.
Well, the Act does not, as Ms. Parks said, specifically make reference to security deposit, but there are a number of cases that have gone to court where persons have challenged the fact that their landlord has charged them a security deposit. And there's the section of the Rent Act, the Rent Restriction Act, Section 24, that that section speaks to the issue of payments in addition to rent. So you're supposed to pay your rent, but if the landlord asks that you pay something else, and this something else, when examined, seems to be a penalty or something that ought not to be charged, and the court would strike it down and say to the landlord, no, you cannot charge that. But in some instances, the court would look at the sum that is charged and examine what the landlord say that this sum is for, and find that it is not an unreasonable for the landlord to charge this sum. And this sum very often is called a security deposit. But there have been instances where a landlord will ask, let us say the rent is $30,000 a month, and the landlord asks the tenant to pay 150,000 and call it a security deposit. When you examine that figure, you can say, boy, something is wrong with that. $150,000 is not a reasonable figure to charge as a security deposit for a $30,000 rent. So it seems to me as if this sum represents something else other than a security deposit. And the court has examined what a security deposit is supposed to be. What is it to be used for? What does it represent? Is it truly a deposit? Because a deposit represents something that you're going to get back, yeah? And so if for example, you have an agreement with the landlord that says that when you pay this sum, you're not going to get it back. Right. Or you're not going to get it back under 3 years, or put some condition on the return of that sum that is unreasonable when you look at a regular landlord-tenant situation, then that payment will be found to be not properly a security deposit. It could not be regarded as such. So there are certain factors that a court would look at. What I can do as we go along is to pull up the section of the Act and read it so that you can hear the words, the language of the legislation, as it now talks about any payment that a tenant is asked to make other than the agreed rent.
Well, it seems it's a good thing you mentioned that, because we already have a question online. Somebody is asking, does the Rent Board Act have clauses or subsections?
Absolutely. Numerous. It has clauses and sections and subsections dealing with all kinds of things. It deals with standard covenants governing the relationship between landlord and tenant. It sets out certain things that even if you have an oral agreement, an oral understanding between both of you as landlord and tenant, what the Rent Restriction Act has in it are certain covenants that will govern the relationship between landlord and tenant. So, for example, if the landlord wishes to come in and inspect, it has to be after giving reasonable notice, for example. Right. Our covenant is that the tenant is supposed to pay rent. And if you want to evict the person, then the Act governs the circumstances of eviction and what kind of notice you give and all of that.
I want to get into something that seems a little more controversial. Based on my research coming into this, preparing for this interview, one of the things that generally obtains, or one of the things that most persons tend to say is either the landlord or the tenant. The legislation is in favor of the landlord or the tenant. If you're a tenant, you say it's in favor of the landlord. If you're a landlord, you say it's in favor of the tenant. Now, I want to get from you ladies, which one is it? Is it really so, or is it just a myth depending on where you sit?
It is not a myth. Okay. It is so.
So who is it skewed in favor?
It is skewed in favor of the tenant.
Okay.
And I don't recall if Paula had said earlier that part of what the proposed amendments will seek to do is to balance.
Bring a balance. Okay. How do you find, how will it exactly strike that balance, essentially? How are you seeking to create clauses that strike that balance in favor of landlords and so on? Even though some tenants may very well say that, they have too much power as it is already.
Well, we have come up with some proposals. One of which I mentioned already is the matter of security deposits, and also look at standardization and the necessary guidelines to get security deposit. But that is why we're actually having the consultation, the public consultation.
Okay.
Because apart from the main provisions that we are sharing with the public at this time in our consultation, we're also listening to the feedback that we have been having, and we have been having excellent feedback from the public. So basically, based on what they are saying, because there are a number of the members speaking about the issue with the water.
Right.
The water bill.
Bills, exactly. Bills is one. Bills is an issue.
Yes.
And the fact that the landlord at this time does not have the right to say to the NWC to disconnect the water for non-payment.
Right.
If the tenant leaves, then they are liable for payment for that. So in so doing, we are listening to the landlord woes, as you would call it, and tenant situation concerns as well. We're looking at both and we're seeing how best we can ensure that the provisions are either amended or additional provisions are included in the legislation to ensure that both have rights, and not only rights but responsibilities on both sides as far as possible.
No.
I don't know about striking a perfect balance, but we will seek to do so.
No, on the issue of the rental agreement, that seems to be something that also generated a lot of discussion. Or when I was doing my research, that was something that a lot of persons had something to talk about. They wanted to know, how do you determine whether a landlord presents you with an agreement that has things that are allowed, are permissible, that they can make these kind of claims, or when they say, for example, the agreement may say something like, I can come to the house at whatever time I feel like, or something like that. but you want to make sure that such a claim is permissible. How does one verify that, and how does one, go about making sure that you're not necessarily taken advantage of?
Good question. Of course, this would not be applicable to all persons because it would come at a cost. You can consult with an attorney and ask them to vet the document that the landlord has given to you. Because we need to remember, that once the landlord gives you, as a prospective tenant, a document, this is a contract. It's a legally binding. This is a document that creates or that establishes the boundaries of the relationship between the landlord and the tenant. And the landlord is likely to create a document or give you a document that will be in his favor or her favor. Right. I mean, nothing is wrong with that. It is now you. You have a duty to yourself to make sure that you check it carefully. If you're unclear about certain things, you talk to a professional, somebody who is trained in looking at contracts, which would be a lawyer, and ask for their view and their guidance as to whether or not this is unreasonable, unfair, these things should be taken out, it should be amended, or whether there's anything in it that is likely to create unforeseen problems for you or undue problems for you. Another thing that you can do, you can call the rent services unit, and they can give you some guidance as well. Or you can pull up the Rent Restriction Act. It is, Google it.
Okay.
It's online. You can look at it, and one of the schedules to the act sets out the landlord covenants and the tenants covenants. So you can see some of the things that the landlord ought not to put in a contract. Okay. That would be, those clauses that may seem to be contrary to what the Act says.
Okay. We're speaking here with Mrs. Rose Bennett Cooper from the Rent Assessment Board and Mrs. Paula Parks from the Ministry of Economic Growth and Job Creation. We're talking about the upcoming amendments to the Rent Restriction Act. Please send in your questions or comments. We have them right here. Take advantage of the opportunity to ask them all the questions and get some of the things off your chest. I know this should be a topic that many persons, as I said before, everybody has a landlord or a tenant story that they can just park.
But
right
more than the landlord
pocket.
or the tenant story, is that everybody, you might not stop to think about it, but you are either now a tenant or you're a landlord, or you have a family member who is a tenant or a landlord, or you grew up in a home where your parents were tenants or they were landlords, or you're going to work in a space where there's a tenant, a landlord. So whichever direction you look, you are in some way connected to this kind of relationship, even though you may not be aware of it. Do you know when you become aware of it? Very often when there's a problem.
Exactly.
Or when you're looking to rent. Yeah, when you're looking to rent or you're looking to leave.
Exactly.
So you may have paid a security deposit and you're now ready to leave. And the landlord said to you, boy, you're not going to get the security deposit until 6 months, or you're not going to get it back because of X, Y, Z.
Exactly.
And when you check X, Y, Z, you say, but when I came to the place, X and Y existed.
Exactly.
And Z, you couldn't expect me to do anything about Z, because if I live in the place, I must walk on I must touch the wall. There's
a specific question I have and I want to talk to you about.
But, so believe me. If you go in the general area, you see a lot of construction taking place, and part of it is because persons intend to enter into the landlord-tenant relationship, you have to get a good understanding of the distinctions when you're dealing with a student who is a boarder. How do you know that you're a boarder? Or how do you know whether or not the person living with you is a boarder, and therefore when you call the rent board, they will say to you, but we don't have any jurisdiction over that, because once you're providing a meal to the person, then this person is a boarder and not a tenant. So there are some unique and interesting distinctions that you may wish to explore or to ask about, and get some clarity as to therefore what are your rights if you're not a tenant. Do you still have any rights? Or if you are the person who renting to if you're the person with whom the boarder lives, does it mean that you don't have any rights that a landlord would have? Does it mean that the boarder can get away with certain things, do what they want? So come out this evening and we can explore some of those. When you throw the tough questions, Ms. Parks will answer them.
Ms. Parks, So can you say when the other ones are coming up, or you don't have
and
that
the location?
Right, well, we have done a number of them already. Montego Bay, Maypin, Mandeville, Harborview, and we did one earlier this week at Boulevard Baptist Church.
Okay.
So,
and what has the feedback been like? What has the
Excellent.
reception been like?
Feedback been excellent from the public, and we do urge and encourage the public to really come out and voice your concerns. We're going to see going forward whether or not we set up something on the website so that persons can send in their comments. Going forward, we're basically almost at the end of our public consultation for now. But
Is this today's? This is not the last one. We have
there's
3
one
more.
more, but no, basically it's the last.
Okay, the last one for the public. The one that is remaining is for the professional groups. Oh, wow.
So can you talk to me about what
Right.
stage the amendment process or what stage of the amendment process the act is at now? I mean, beyond the consultations, what stage are you so persons can understand and follow along how the process is going itself insofar as amending the act?
Well, first, normally we would have, we had a committee and also the members of the rent board and other person who would have sat together for quite some time and put together some proposals in relation to amending the act. And we would seek cabinet approval then to issue drafting instructions to the Chief Parliamentary Council, who would then do a bill. When we get the bill, we pull some of those provisions, the main provisions from it, and then go to public consultation.
Okay.
What we're seeking to do, what we need to say at this point is that these are still proposals at this point.
Okay.
Right? We listen to the public. We then would have to go back to the table, look at some of the concerns that the public have. Look at all the concerns that the public would share with us, and then we would now prepare further draft instruction to the CPC, which is the Chief Parliamentary Council, that will now move along to do another bill, and we then would go back and forth in settling the bill. If there is need for us to continue public consultation even afterwards, then the ministry could look into that.
Okay.
In doing so, because we really want to ensure that, apart from voicing their concerns, that they are all fair and aware of what is coming and what is being proposed.
Yes.
Okay.
Now, let me go back into the thorny rental issue and now talk. How does one ensure that a rented premises is registered with the Rent Assessment Board? Or how can one person essentially, I would imagine there's a lot of informality that obtains a lot of the time, and that does that kind of create a situation where a person does not enjoy the protection of the rental or the act or anything like that, or is it only a situation where if the premises is registered with the Rent Assessment Board that a person can come in and make a complaint and feel like they'll get some kind of recourse or redress?
You can come in and make a complaint and get redress whether or not you are registered. It is recommended that you register, though, because that expands your ability to access certain services and information. But if you are a tenant and you have a difficulty with the landlord, then you contact the rent board, the rent services unit, and they will guide you as to the steps to be taken.
All right. And now, what is the distinction between major and minor repairs in a rented home? That was one question that I came across that seemed to be because a lot of persons would say, for example, I live in the house, there are some challenges, I have a problem, I decide to fix something and then and take it out of the rent. Right, but when they approach the landlord about it, they say, "Well, no, you can't do that. I want my full rent because I'm not. Either I'm not responsible for that. You should fix that, or something like that." And so it's like a thorny issue. It's like a gray area.
Yes, it's very thorny.
So it's a gray area. So can you bring some clarity to what should obtain a situation like that?
Well, I think that would be a little subjective, but it really should be a matter that should be discussed at the beginning of the tenancy and agreed upon between the landlord and the tenant. That is the best way to do it at the beginning of the tenancy. We can assume that major repairs will involve maybe leaking roofs and so on, but that is an assumption depending on what the leaks are. It may be a whole leak, you know what I mean, or something to that effect. But I don't know if we can sit at this point and decide that. Okay,
well, some and some of them are self-evident because if big wind come and blow off the roof and rainwater coming into a part of the house, and you say to the landlord, hello, a piece of the roof is missing, it can't be that either yourself or the landlord would consider that this is a reasonable thing for you to deal with as a minor repair. If in your bathroom a toilet is leaking, it's a flapper ball. That is a correct term, gentlemen. Yes, thank you very much.
Yes, it's a flapper ball.
There are certain things it's kind of obvious. And then some tenants will say, listen, this I'm renting somewhere, my rent is $60,000 a month. There's this thing that needs to be fixed. It's going to cost $2,000-3,000. It's an electrical, it's whatever. It's easy. I've asked the landlord 3 times to fix it. It's easier for me to fix it and quarrel with him about it or negotiate with him subsequently. But if it is something that is going to cost you a couple of $100,000, so there are certain things that you can use as a guideline to determine whether this would be major or this is not. But as Ms. Parks says, there are several things that you'd have to negotiate at the beginning. Right. And one of the ways that you can negotiate it is to ensure that in your contract you can put in a clause that says that any repairs that is under $3,000 would be the responsibility of the tenant. So there are certain things that you can do to narrow the scope of any dispute as to major and minor repairs.
All right. Now, is advice for persons in arrangements where they are sharing water and electricity and think they are being either overcharged or being taken advantage of? For example, in a situation where there's one water bill, for example, and everybody is expected to chip in, so to speak, and a tenant may feel that, okay, I'm being charged too much based on what I think I use relative to what other members of the household may use. So how do they go about, if they have a complaint, what kind of advice can you offer them in that situation?
Well, I would tell them, similar to what you said before, at the outset, you're going to share certain utilities. You have a formula that will determine how you apportion the bill when it comes. So, for example, if the house is X square feet, you can do it by virtue of measurement. I occupy X percentage of the building, so I will be responsible for X percentage of these maintenance or utility charges. Or you can do it based on occupancy level. You can say, well, I have 5 persons, you have 3 persons, so therefore when it comes, we divide it by 8. You can divide it based on your understanding, the expectation of how often or how much time per day, per week, per month you're going to be there versus the other person, and work this out at the beginning. If during the course of the relationship you realize that that is not really fair, it's not working out the way you'd expected, then you try to negotiate. And if the persons are reasonable, you can come to a reasonable understanding, because you can work out any wonderful formula at the outset. And a tenant comes in and kiss them teeth and say, boy, you can't go on, because if me not pay, you're going to have to pay it, because you're not going to want it cut off for you. And in that instance, which now comes to the other part of the question of what do you do when it happens, you can contact the rent services unit and they can guide you through certain steps that you take, whether you're going to now involve the police dependent on the nature of the difficulty that you're having, or whether you're going to initiate a suit against the person through us, or whether we'd recommend that you go to the court, or what steps you can take.
All right, before I come to you, Ms. Parks, I want you to, as we move into wrapping up, I want you to just think for a minute about the overall vision and purpose that this new act is expected to. I mean, you said you wanted to strike a balance and so on, but get into a little more detail about how you expect to accomplish that through the act. But Miss Bennett Cooper, I wanted you to just elaborate in a little detail for persons who may be unfamiliar what the basic function of the Rent Assessment Board is and how exactly they can utilize it to, I guess, get redress, recourse, whatever it is that they may need.
Well, you can think of the Rent Assessment Board almost like your rent court from one perspective, because if you've got disputes with persons as in terms of your landlord and tenant relationship, you wish to sue, let's go to the big girl in the room, and you wish to sue the person, you can do that through us. And our board sits as the court, as the judges that will hear your matter and arrive at a decision. And when that decision is arrived at, it is the equivalent of a decision of your resident magistrate, now called the parish court. And if you're dissatisfied with that decision, you appeal to the Court of Appeal. So this is your rent court, where all your disputes as it relates to anything to do with money, this is a place that you can come to, and you can choose to come to us or you can go to the court. One of the benefits of coming to us is that we tend to move a little bit more quickly, because the burden on us in terms of the number of cases that we handle is less than the burden on the court. And so usually within a month and a half or so, you have your documents are served, someone's prepared, served, and so on, and you get a date for your hearing. And once you get a date, usually within 1, 2, 3 sittings, the matter is disposed of. And sometimes it is disposed, many times it's disposed of at the first hearing. It usually would go beyond the first hearing if persons do not attend. This is also the place that you come to if you're dissatisfied with the amount of rent that is being charged. And I mean that for both landlord and tenant. If the landlord is saying, listen, I rented the place to you at $30,000 a month, and even though the law permits me to have an automatic annual increase of 7.5% automatically every year. I think that there are several factors that would allow me to go up to 15 or 20% increase. But before I can do that, I now need to go to the rent assessment board that would come in and do an inspection and do an assessment to determine whether, in fact, this proposed 20% increase is one that would be reasonable. And then there are certain things that they would look at, whether the place has been improved, what has been happening with the location, did the landlord give you an extra room, build a room, give you a veranda, give you, and so on. And also too, if the act automatically includes you as one of the controlled properties over which we have jurisdiction, you can apply to us to get an exemption. Unless you get that exemption, then you come under the jurisdiction of this act, and we can make a decision as to whether or not the rent that you're charging or the rent that you're paying is too high, too low, whether there should be a refund, whether there can be an increase, and so on and so on and so on
and so forth.
Yes.
All right, over to you, Ms. Parks. Talk to us about legislation and the overall objective and striking that balance, and how exactly you're working to achieve this.
Okay, well, first I must say that the primary justification for rent control legislation has always been to reconcile the interests of landlord and tenants while ensuring that neither party, by means of manipulation, operates to the detriment of the other. Now, based on the steady number of disputes that we've been having both at the Rent Assessment Board and from the courts, from both landlord and tenants, we realize that in most persons or the public opinion, then the current act does not adequately address these challenges. Additionally, many landlords have said to us that the act is obviously more skewed towards the tenant, because they seem to have more benefits. Most of the fines and penalties are on balance because it's mainly in relation to the landlord and so on. So from where we sit, we have listened to the complaints. We understand in general what are some of the vexing issues on both sides. So we have sat down and we have actually put together some proposed amendments in relation to certain provisions. These provisions that is actually creating some of the challenges, like for example, looking at minimum standards for rental premises. We have challenges from tenants who say that we have to pay our rental every month, so the roof is leaking, but my landlord refuses to fix the roof, for example, but they still have to live somewhere, difficult to find somewhere else to move, so they have to deal with that. So we have looked at the legislation and incorporated some additional landlord covenants in relation to that. We look at the matter of a raise of rent and the fact that landlords are complaining that in order to recover their property, if someone owes rent for several months, by the time it takes them through the court, the tenant leaves the premises with them leaving a lot of bills, unpaid rent and utilities and so on. So we look also at the provisions in relation to that to see how best we can say, okay, well, in that case, some additional penalties would have to be, or some provisions would have to be in there to sort of bridge that gap, and also in terms of timely adjudication of the cases. Hence, one of the provisions or one of the recommendations we are having is to expand the powers of the current Rent Assessment Board to deal with the matter of recovery of possession. Not that this is going to be taken from the parish court, but then persons would have an alternative and would have the opportunity to have their cases heard in a timely manner. Now, as I mentioned before, we have put together the proposals, and that is why we're doing the current public consultations, because while we have these, we share it with the public, then we will hear now from landlord and tenants, this is what we're proposing. Is there any concern that we may have missed? Hence, we need to go back and amend. Is there anything that we didn't think about at all? We have not touched the matter of the water, for example, that has been coming up in all the consultations. And it means know that we are going to have to look back at the legislation and see how best, and it may consider amending another act. That is outside of our jurisdiction. So that is how the ministry is seeking to bring a balance to the situation. In addition to that, though, according to our Vision 2030, and the draft National Housing Policy that is currently being developed by the Ministry of Economic Growth and Job Creation, it is one of the main objectives is to provide access to legal, safe and affordable housing to all Jamaicans by 2030. And while we believe that everyone may not own a piece of rock, but at the same time people should live in adequate housing, and we believe if we amend the Act, which is one of the recommendations in that policy document, then it will make the rental market more viable, and then persons, landlord and tenant alike, will say, listen, I can rent my property because I have somewhere to go in case there's a ghost, and tenant can feel protected, and so on. So basically, it is not just on the part of the government, but also we need the feedback from the public to make this happen.
All right. Okay. All right, you mentioned fines and penalties a while ago. We didn't discuss that, but is there an area where persons can go and find those and have an idea?
I have it right here.
Okay,
but no, actually no. Fines and penalties. My brain is on the security deposit and the issue of how it is referred to in the Act.
Okay.
Remember, I had said earlier that I would tell you what it says.
Right. You did actually mention that, yeah.
Which is entirely different from the fines and penalties that are now on. So you go ahead with the fines and penalties.
So where persons can find it and have an idea where to look, so that if they wanted to find out what the ranges of fines and penalties, because you mentioned that we didn't discuss it. Well, I mean, how do those come into play, and where can a person find out what those are?
Well, some of them are already contained in the Act, but they're by no means punitive.
Okay.
So, because for example, assaulting an officer, I think it's either 500 or
1,000. Yeah.
Okay, so those you might have to look into that as well.
Revising them upwards so that people may see it as a serious breach of the Act.
And they're located in the Act itself.
In the Act itself. And we want to encourage persons not to only know their rights, but their responsibilities on both sides, both in relation to the landlord and in relation to the tenant.
Okay. And these fines and penalties are in relation to breaches of the provisions of the Act. Okay. I should mention this is a little contentious in the sense that, and it came up yesterday where someone was saying to us that it appears that most of the penalties or the fines are imposed on landlords when the landlords do or fail to do certain things.
Right.
So, for example, it is a covenant of a tenancy that you must pay rent, but if you fail to pay the rent, it's not that there's a fine.
Right.
So when the tenant is in breach, there appears not to be any fines.
Yes,
there are a handful of them, but nothing significant, and that's one of the ways in which the landlords are saying, "Listen, man, this thing is still." Imbalanced. One person said to me, "This still don't feel like you strike a balance." That give us more rights, but but
I guess you'll take it into consideration and take. My final question before I wrap. This is somebody who asked me this the other day, and I just I researched it and I know the answer, but I want you guys to tell them the answer. What should a landlord do if you have a tenant? You want to evict your tenant who is not paying their rent or not basically holding up their end of the bargain. It's not as simple as calling the police or having them removed. There are some provisions involved in that. So I just want you to explain that to persons so that they don't, they don't take certain actions that actually results in harassment. Affects them negatively, right?
Because if they take certain actions, if you've got a tenant that is not paying rent, these actions could be deemed harassment under the Act, which then becomes a police matter.
Right.
So the straight issue of non-payment of rent, you want the tenant out, your option is to serve a notice to quit on the basis of the non-payment of the rent.
Right.
The trick to that, well, not a trick, the thing about that, though, is that when the tenant pays up the rent, then your basis for evicting the tenant is gone.
Right.
So you can't say, well, I still don't like this tenant and I still want you to leave, because the reason for the eviction notice would have been extinguished.
Right.
So therefore, you give a notice saying that you failed to pay the rent, you owe X number of months rent or X amount of rent, and you should pay it. And once it is paid, then the matter is at an end. You and the tenant go on into the sunset. But that's your only option. If you choose to try and lock out the tenant, double lock the door and do certain things.
Cut off the water, cut off the electricity.
As one person to take off piece of the roof, this is not on.
Right. All right, ladies and gentlemen, thank you so much. I mean, there's so much more that we could talk about, but the good thing about we have another question coming in at the last minute. Go ahead to my technical advisor. Oh, okay. It says here, can landlords charge late fees for late payments? If yes, what percentage?
This question. Was it yesterday? Yes. And interesting, it takes me back to exactly what I was talking about in terms of the security deposit, because the section of the Act, the relevant section of the Act that I would use to cover that question is Section 24, which says that a person shall not, as a condition of this tenancy, require the payment of any fine, premium, or other like so on and so forth and so on. And what this section is saying is that if you rent some so if you rent somewhere, the only thing that you really can ask a person for is a rent.
Exactly.
So someone is saying, so what if the person don't pay the rent and I want to charge them interest on the rent? And the court, I was advised 2 days ago that there's a recent decision from the court, which I need to have a look at that judgment, where the court is saying, and I'm not sure whether it is Court of Appeal or Supreme Court or Parish Court, is saying that you're not supposed to charge interest on the rent. No, I have, as an attorney who's been in this field, who's been practicing law for a very long time, I have issues with that kind of decision. I don't know what were the arguments that were put before the court in arriving at this decision. It is my view that you should be able to charge interest on late payment. It is also my view that if you've got a valid contract and the contract is properly worded and it is included in that contract, that you can charge interest, and it's not interest that is punitive, that would be found unlawful, then it should be allowed to stand. And the same kind of argument goes with the security deposit. As long as it's not punitive or an inappropriate figure, it should be allowed to stand. And what the new provisions in the amendment, well, part of what we're considering in the amendment is, as Ms. Parks said, to address the issue of security deposits, and know that this issue of interest is coming up more than once. It is something that we should perhaps consider.
Seems that way. It seems
whether
like
the act should make specific reference to it and make it an exception to Section 24, or to outline the circumstances in which you can charge interest on late payment of rent or late payment of rent, and to create some kind of construct within which that interest can be charged. Yeah.
All right.
Yes.
Okay. Well, ladies and gentlemen, it's time for us to wrap. Thank you to everyone who tuned into our discussion, especially those of you who sent in comments and questions. Right away, let me just big up Mr. David Fisher, Michelle Nicole Hyman, Nguvuna Ujasiri, I hope I pronounced that right, don't hold it against me. Jerome Johnson, Sharon Peaches Frey, who's sending in her comment from London, appreciate it, really appreciate it. And everyone else. If you sent in a question and we didn't get the chance to answer it, not to worry, we will be going through afterwards and answering questions, and we'll be, if necessary, we can farm them out to our guests here so they can provide them, so persons who can watch the video again later, they can hopefully get the answers that they want. Remember, our audience plays a major part in our show. If there's anyone in particular you'd like us to have in studio, let us know, and we'll try our best to have them in studio as soon as possible. Don't forget to follow us on Facebook, Twitter, and Instagram at Jamaica Information Service to see who will be in studio next. We do this every Thursday live right here on Facebook. I've been your host, Vaughn Davis, and this has been Studio 58A Live. Quickly before I do that, let me just give you the contact details for the Rent Assessment Board. They're located at the Towers, 25 Dominica Drive, Kingston 5, phone number 876, because we have 10-digit dialing now. 876-926-1590-3 and 876-906-1765. Ms. Parks, if somebody wants to call you and ask you a couple of questions, how can they get in touch with you?
Same numbers, because we're located in the same location.
All right, wonderful.
So the same numbers.
All right, we do this every Thursday. I've been your host, Vaughn Davis. Thank you so much for tuning in, and please have a good day.